So, in past classes, some students have been confused by the difference between criminal cases and civil cases. The purpose in this video is to help to clear up the confusion. First of all, some of you may ask, why is it important what the difference is between a criminal case and a civil case? First, in most criminal cases, the defendant must have a bond or wait in jail until their court date. In civil cases, nobody has to choose to either pay a bond or wait in jail. Second, if a criminal defendant misses court, the judge will issue an arrest warrant. Parties in a civil case are not arrested if they miss court. Third, there are a bunch of rules that apply in a criminal case that do not apply in a civil case. For example, criminal defendants are entitled to court-appointed lawyers if they cannot afford to hire a lawyer on their own. Fourth, in a criminal case, guilt must be proven beyond all reasonable doubt. Civil cases have a lower burden of proof. I expect to have a separate video about the different burdens of proof. For now, just understand that the burden of proof in a criminal case is much higher than in a civil case. And finally, in Texas, the Court of Last Appeal in a criminal case is the Court of Criminal Appeals in Austin. For a civil case in Texas, the Court of Last Appeal is the Texas Supreme Court in Austin. So, what is the difference and how do you know when you've got a criminal case instead of a civil case and vice versa? To start, in every criminal case, the defendant is facing the possibility of jail, prison, or a fine. Not just the possibility, but that is the main goal of whoever is prosecuting or whoever has filed the case: jail, prison, or a fine. There can be a difference between jail and prison. Usually the prison is bigger and the inmates are scarier, but in both cases the inmates are behind bars. For small crimes, the defendant might have to serve only 1 day in jail, and for a really small crime, the defendant might have to only pay a fine. But it is still a criminal case. For example, running a stop sign or speeding is usually punished by a fine less than $500, but getting a ticket for running through a stop sign or a ticket for speeding is still a criminal case. Getting a ticket for parking in a fire lane is a criminal case, just as much as a murder charge. Obviously, the punishment for murder is a lot more than a fine, but the ticket is a criminal case and has much of the same procedure as a murder case. Some people think a case is not criminal if the defendant gets probation instead of jail or prison, but those people are wrong. What happens if a defendant does not qualify for probation? Answer: they go to jail. What happens if a defendant violates their probation? Answer: they go to jail. Saying a case is not criminal because the defendant got probation is like saying it's not a gun if you never pull the trigger, or it's not a pizza if you never take a bite. In civil cases, with some important exceptions, jail, prison, and a fine are never a possibility. We'll discuss the exceptions in a moment, but generally civil cases are not about locking somebody up or about punishing somebody. A civil case can be about dividing the estate of a dead person according to their last will and testament. A civil case can be about dividing property in a divorce. A civil case can be about a boundary dispute between neighbors. Or a civil case can be about which candidate won an election. A civil case can be about money compensation, but civil cases do not focus on punishment or incarceration. Another thing about criminal cases is who starts them. Criminal cases are started by the police, by a prosecutor, or by a grand jury. For example, when a highway patrol officer writes a ticket, the officer will give a copy to the driver, and the officer will take another copy to a judge. When the judge gets a copy of the ticket, then the criminal case starts, and the judge will set the case on the judge's calendar. If the person who was ticketed does not come to court on the day the calendar says they have to come to court, or pay the fine on the day the calendar says they have to pay the fine, then the judge will issue a warrant for that person's arrest. Here's another example. If an officer writes a parking ticket and puts it on the windshield of a car, the officer will take a copy to the judge, or to a judge. The criminal case will begin against the owner of the car according to the records for the license plate. For the criminal case to start, it does not matter that the owner did not park the car, and it does not matter that the owner did not sign the ticket. The owner is still charged with a crime because the ticket was filed with a judge, and the owner of the car could be arrested if the owner does not go to court or pay the ticket. When the owner gets to court, the owner can then plead not guilty and try to convince the judge or jury that somebody else parked the car. And maybe the judge or jury will believe the owner. If a prosecutor files a case with a judge and the defendant might get jail time or a fine, that also starts a criminal case. If a grand jury indicts somebody for a crime, the indictment will be delivered to a judge who then puts it on the judge's calendar. The defendant must either then go to court or then be arrested. If a case is not filed by the police, by a prosecutor, or by a grand jury, then it is a civil case. A random person cannot file a criminal case with a judge. Sometimes people say that a random person filed charges. What they really mean is that a random person convinced a police officer or a prosecutor to file charges. It required a prosecutor or the police. On the other hand, a random person can file a civil lawsuit, but they cannot file criminal charges unless the police or a prosecutor does it. You might have heard people talk about dropping charges. Once again, that cannot be done without the police or a prosecutor. A crime victim might ask the prosecutor to drop charges, and the prosecutor has the power to ignore them. That is why when a person is charged with a crime in Texas, the case is called the State of Texas versus whoever. If I got arrested, the case would be called the State of Texas versus Patrick Brady, even if my crime as a victim, and even if that victim wants to drop charges, the prosecutor can proceed with the charges because the victim is little more than a witness. Another example, if the United States puts charges on somebody, then the case is called the United States of America versus whoever. So, a criminal case requires two things. One, it must be filed by the police or by a prosecutor or by a grand jury. And two, the main possibility is for somebody to be punished with jail, prison, or a fine. Now let's talk about the weird cases that can make this confusing. First, sometimes prosecutors and police file cases, but the cases are not criminal, because the main possibility is not punishment by jail, prison, or a fine. For example, prosecutors and police sometimes file a case to forfeit property. In that situation, the goal of the case is to take somebody's property, not lock them up. Another example, prosecutors sometimes file a case for a protective order. In that situation, the goal is to get an order signed by a judge. At least at the beginning, the goal is not jail. Jail might come later, but the main goal is simply an order signed by the judge. Another example, prosecutors sometimes file a case for child protective services, but the goal is for child custody orders, not to lock somebody up. If the main goal is not punishment by jail, prison, or a fine, then it is a civil case. Sometimes prosecutors ask for restitution during sentencing in a criminal case. The law allows prosecutors to ask for restitution, and the law allows judges to order restitution as part of sentencing. But the main goal of a criminal case is punishment, and compensation to the victim does not change the main goal. In criminal cases, some defendants never pay restitution, even though they are ordered to. But those same defendants serve decades in prison. Sometimes a random person can ask for exemplary damages. That's damages that are to make an example out of the defendant. It's punishment. Exemplary damages are money that a defendant must pay in a civil case as punishment. Exemplary damages are like a criminal fine because it is money that is paid as punishment, but exemplary damages are like the tail on a dog. The dog is compensation for medical expenses, lost wages, and the like. The tail will not wag the dog, and the defendant will not be ordered to pay exemplary damages unless the defendant is first ordered to pay compensation to the victim. It is possible to have a criminal case and one or more civil cases going for the same incident. As an example, if a person named Joe assaults a person named Rob, Rob could sue Joe, and the lawsuit filed by Rob would be a civil case for two reasons. One, Rob is the victim. Rob is not the police. Rob is not a prosecutor. Rob is not a grand jury. And two, Rob is looking for compensation for his injuries. But also, Joe could be arrested and charged with assault, which is a crime. That is a criminal case, because the goal is to punish Joe for his conduct, not to get compensation for Rob's injuries. Contempt of court is another confusing situation. I will make a separate video about that. But for this video, let me simply say that judges have the inherent power to put a person in jail for intentionally violating a court order. The best example of that is when parents are jailed for not paying child support. So I hope that helps you understand the difference between a civil case and a criminal case. If you have any questions, feel free to call or email me. Thank you.